Hello, this is Sudhir Kumar Dwivedi, Assistant Professor of Law, Gemtech School of Law, Greater Noida. The topic for today's lecture is what is the concept of the pleading, and this lecture I am going to deliver under the subject drafting, pleading, and conveyancing. In this lecture, we will see what is the pleading, what is the drafting, what is the history of the pleading, and later on we will see what is the modern concept of the pleading, means to say nowadays how the pleading has taken place. First of all, let's see what is the pleading. If we see the general definition which is provided in law dictionary, it means a formal statement of the cause of action or defense. So if you analyze this definition which has been given in the law dictionary, it says that is the statement of the cause of action, means to say if any cause of action has been arise in favor of any person, then he may state his action, he may state his cause that such and such cause of action has been arise in my favor, that's why the other party is liable for the thing. It may be compensation or it may be some other type of the punishment and all things. In the same way, the defendant side, the defense side may also plead that though the cause of action have been arised in his favor, but this is my defense and that's why I am not liable to pay the compensation or other any type of any other thing which has been law supposed to impose on him because of that cause of action, because he has valid defense against those cause of action. So in nutshell, it can be said whatever has been stated by the parties to support his cause of action and whatever has been stated by the defense side to revert the cause of action or to oppose the cause of action, all both things fall in the category of the pleading. Now let's see what is the drafting. Drafting in general sense is putting one's own ideas in written form. Whatever is the idea of any person and he is putting those ideas in written form, then it is said that he has drafted something. In legal sense, it is considered as a legal connotation, which means putting own ideas in writing. Drafting is not an easy task. It is a matter of art. The reason being why it is considered as a matter of art, the reason being it required not only knowledge. If we talk in the concept, in the context of law, then it not only requires the knowledge of law, but it also requires the procedural aspect of the law. It also requires the settled judicial principle, knowledge of the settled judicial principle, and it also required the proficiency in language. So if one person is well versed with the knowledge of the law, with the settled judicial principle, but if he is weak in language proficiency, then he will not be able to draft the good pleading, or he will not be able to present his ideas. And since if he is not able to present his ideas, then it will said that he is not able to communicate the thing what is in his mind. And in the legal context, if he is not able to communicate the thing what is in his mind, then there will be no use of such knowledge or such you can say the pleading. One can ask, what is the need of good drafting? Suppose if the party or the advocate, whatever has been communicated by the party, and advocate has drafted a pleading in that regard, and it is not regarded in right sense, means to say the pleading is defective, then it will not create only difficulty to the opposite party to take the defense, but also it would create some difficulty to the party for claiming his right, as the bench, or we can say the judges, will not be able to understand actually what the party is claiming. So the good drafting is very essential part of legal practice, and good drafting may be of any kind, like civil drafting of civil pleading, drafting of criminal complaints and other proceeding, writ petition, appeal, civil or criminal, writ revision cases, civil or criminal review, and etc. So whether you are thinking to pursue your career as an advocate, or thinking to pursue your career as a judge, or thinking to pursue your career as independent lawyer, or to want to establish a law firm, whatever is your field, if the student, it means to say, if the person who has studied the law is not able to draft good pleadings, then it is no use of knowledge or law. Because unless and until in this profession, if you are not able to represent the things before the opposite party or before the judge, then there is no use of such knowledge. That's why this subject is very important in all aspect, and that's why it has been made a compulsory subject in law course, and students have to study this subject. So let's see what is the history of the pleading. If we talk about the history of the pleading, then we find that it was existing in the ancient era, but not in the same sense or same form as it is existing now. In the ancient time, the pleading was generally oral, means to say, whatever is the claim or whatever is the defense, the parties were representing himself before the king, or you can say they were representing before the panchayat, and they were orally communicating the things, and the panchayat or the king, whatever the stage of the case, they give the judgment on the basis of their oral pleading. It was in the era of Edward II in England. First time the word issue was taken as a legal context, means the code, the Edward II, in the era of Edward II, the word issue was used in the context of law, and if there is some dispute between two parties, then it was considered that there is an issue between two parties. If we talk regarding Indian scenario, we know that our Indian ancient culture was based basically on the basis of dharma. So everything was looked in the eye of dharma. What is right, what is wrong, it was decided generally on the basis of dharma. So if someone has any claim, or someone has taken wrong path, then it is generally the people present himself before the purohit, or the, you can say, guru, in guru, and they put their claims before the purohit or guru, and the guru or purohit decide their case on the basis of dharma. At that time also, there was no concept of the written pleading. However, with the development of the time, if we talk about at the stage of ancient time Gupta, in the, you can say, rather than in the, at the time of the Mughals, the one format of the pleading which got its place in judicial system was the farman. Generally, the Mughals issue the farman to call the people to present before himself. Means, if the king want to call any person in any particular dispute, then they generally issue the farman, and the parties are asked to present himself before the emperor, before the king. the Mughal emperor. And when they present, however, at that time also the pleading has not taken place in written format, because the pleading was at that time was in the form of notice, that is the farman. And once the parties are appearing before the emperor, Mughal emperor, they have to orally put their case before the king, and the king will decide the case on the basis of hearing both the parties. And the judgment was also at that time was oral. However, with the development of the time when the British era came, then some modern concept developed by taking into consideration the British laws. And what Britishers started to do, they called the parties by issuing notice, and they asked the parties to present their case. Since at that time the literacy rate was not so good, that's why the written format of the pleading was not at developed stage at that time as well. The Judicature Act 1873 brought many changes in the concept of the pleading in British, and that also affected the situation in India as well. And now the Britishers asked the parties to present their case in written format. The basic reason behind this was that different type of the cases were coming before the court, and the court was not able to differentiate between the case. That's why it was decided at that time that they will first file their statement before the court, and on the basis of their statement it will be decided that which court will hear the case, what type of the case is there, whether it is related with the property, or whether it is related with the money, or whether it is related with the, whether it is criminal case, or whether it is related with the marriage and all things. That's why that was the basic funda behind that, why they call the party to give their written statement, because it was not that it was for their, it was for the feasibility of the case, so that the categorization of the case can be done, and it will be easy for the judges to decide the case on the basis of that categorization. However, it was not easy for the parties, reason being the people were not so literate, and that's why the reach of the court was going beyond and beyond from the common people, and the common people were not able to present their case before the court. This was the reason why the common people were not able to represent themselves before the court. Let us see what is the modern concept of the pleading. In the modern concept, pleadings are the statement of facts in writing, drawn up and filed in a court by each party to aim and a case, stating therein what is the contention shall be at the trial, and giving all such details as his opponent will need to know in order to prepare his case in answer. In India, there are only two pleadings in a suit as defined under Order 6, Rule 1 of the Code of Civil Procedure 1908. It says that pleading means plain and written statement. So it can be said that pleading are a specific document filed by the parties in a lawsuit which state the position of the parties in the litigation, and it is a document that contains claim or counterclaim. Pleading can be defined as a formal statement that requests the court to either grant the relief or pass any verdict on in a dispute. So it can be said that pleading is something which is the statement of the parties before the court, so that on the basis of that statement court may find out the point of issue and give the judgment on that point of issue. As we have seen that Order 6 Rule 1 provides that pleading contain plaint and written statement. So it is important to know what is the plaint. As per order 6, plaint is a statement of claims called the plaint in which the plaintiff set out his cause of action with all necessary particulars. As we have already discussed in the beginning of the lecture, that it is ultimately stating his cause of action before the court. So what was stating a cause of action, it has now taken the name of plaint. So if the party is stating his cause of action with all particulars, then it is called as a plaint. Let us see what is the written statement. A written statement is called a defense statement in general. The written statement which the defendant deals with the every material fact alleged by the plaintiff in the plaint and also sets out new facts which tells in his favor, adding such objection as to wish to take the claim. So in written statement, one side, the party who is filing the written statement can deny the claim what has been claimed by the party in the plaint, and the same time they can also claim something new from the party, means from the party who has filed the plaint. Let's see what is the object of the pleading. The basic object of the pleading is to assist the court and to the parties to the dispute in its adjudication. Its function is of multi-dimension and is in various ways. As we have already discussed in the beginning of the lecture, that the ultimate purpose is that party, by claiming the his cause of action, putting his cause of action before the court, wants some relief from the court, and the defense side, by putting his defense, wants that such cause of action is not existing in against him. That is the basic concept behind this pleading. Let's see one case. In this case, Princeton versus Lloyds Bank Limited in 1941, it was discussed what is the function of the pleading, and it was held that the function of the pleading is not simply for the benefit of the parties but also and perhaps primarily for the assistance of the court by defining with the precision the area beyond which, without the leave of the court and consequential amendment of pleading, conflict must not be allowed to extend. Means to say, it just not help to the parties but it also help the court to decide, to find out on what is the point of dispute. Reason being, it is generally not allowed to amend the pleading unless and until certain legal requirement has been fulfilled. And that's all about the concept of the pleading. Thank you.